Thank you so much.
You're welcome. So I was saying that David has worked as a lawyer for quite some time and also as a certified public secretary in both the public and private sectors. And currently the corporation secretary and head of legal at the Unclaimed Financial Assets Authority. So for today, I'm honored to introduce the concept of unclaimed financial assets, or generally the concept of unclaimed assets as a regime for dealing with assets where they are presumed to have been abandoned until they are reunited with their owners. So I would want to take the participants through a small presentation. And since it's a participatory process, I'll be asking members to chip in so that we ensure that people actually get the concept. So I want to show the team a photo, which is on the second slide. Can you all see the slide with this photo?
Yes.
Okay, thank you. So the whole concept of unclaimed assets revolves around something that we are very familiar with. Now, before we became an institution, there was a member of parliament for Resamis, Mheshimiwa Rekuton, who decided that it was about time that we decided as a country, what do we do with assets whose owners cannot be traced in the meantime. So in 2011, he sponsored a private member's bill in parliament, which ended up being the Unclaimed Financial Assets Act that founded this authority. And then in 2016, they were made some regulations which were meant to improve on the act, or basically to ensure that it can be operational. So UFA has been there since then. And currently we have quite a number of assets. We don't like saying how much is there, because the most important thing is not how much is being corrected, but how much is being given to the owners. So you may have seen those press reports about the 25 billion in cash, which people have not claimed. We'll come to why they have not claimed. There's some reasons, but let's start with understanding the concept. So I have a photo there, and you can see some kids. So this was a photo that was taken in a high school. And what these kids were doing is that they went to the school principal and requested to be given a room. And the purpose of getting this space was there were very many items which other children had lost in the compound. And therefore these three kids would gather these items and store them there, sort them out according to size. If there's a ribbon on the item, trace the owner. If they can't, they just store them there and wait for the owners to come. So I want us to think through this photo. So I would want to ask, looking at this photo, what do you think about these three kids in terms of what is their role or relationship in ordinary language? I'm sure most of you will say you would consider them to be guardians of these items, so they are guardian angels. In ordinary language, you say guardian angels are people who take care of other people, or take care of things that belong to other people. But then when they are taking care of these items, there are other players in this particular environment, the school environment in which they're operating in. We mentioned the school principal. The school principal has basically given them space and a license to operate within the school premises to carry on this noble initiative. So looking at the whole scenario, one can actually see that the school principal will be the equivalent of the government of Kenya, because they have given them the space to operate as a humanitarian organization. In terms of these three kids, this you can actually say there is equivalent of UFA. I would have been very happy if this was a a physical meeting because people can participate more, but now the limitations of virtual sessions. These three kids, you can say they are the equivalent of UFA. In essence, they are trustees for these items. They'll hold these items in trust until the owners come for them. Now, let me ask a question. Suppose some of these items remain for a whole academic 1 year without someone coming for them. Maybe one person can answer. What conclusion would you come to in terms of that owner who has failed to come for them? What have they done? Irene, are people able to unmute and say something?
I think as many, I'm trying to control so that we are not found with a lot of noise, but I think a few can unmute, but most of all, I think we can use the chat.
Yes, okay.
Yeah, if one is not able to unmute, we can use the chat so that we don't end up overflowing with noise.
Okay, so that's fine. So if these kids stay for a whole year without someone coming for a particular item, would we say these kids are entitled to conclude that whoever is entitled to this item has decided they are no longer interested? In other words, they have abandoned this particular item. For whatever reason, maybe they have outgrown the clothes, maybe it is not, they didn't like the clothes after all. But the essence of it, they have basically abandoned the item. Now, as you can see from that photo, this space is not big. So at some point, it should be expected to fill up. So what should these kids do in terms of managing this crisis? Perhaps one of the ways they can deal with the clothes which are not being claimed, the abandoned one after a certain period of time, which they'll agree with the school, is to donate these items to charitable causes, maybe a children's home. And actually on this day, this is what these kids were doing. They are sorting out to donate some of these items because they had remained unclaimed for quite a while. Now, these items that have been found within the school compound definitely have an owner. Looking at the ordinary situation we have at home and at school, we can say that the people who would claim these items, the first person, maybe somebody can answer, who would be the first person who can claim the item? Ordinary, from the normal course of things, the way we know things, it has nothing to do with the law. Who would be the first person who can claim this item? Anyone who has an open mic?
The person who knows they exist, maybe.
And who would be the person who knows it exists, sir? Who would that be? Ordinarily, who would know that is my item? That's my item. Who would know?
Maybe the person who first acquired the item, or was involved in its acquisition, the owner, the original owner.
Okay. Oh, what's your name, sir?
My name is Kelvin. Sorry, I didn't introduce myself first.
It's okay, Kelvin. So according to Kelvin, the person who first acquired the item would ordinarily be the first person who would be interested in coming for it when it is abandoned. Presumably, I would say that is possibly the parent or guardian, Kelvin?
Yes, that's correct.
Yes, so that's the first class of people who would be entitled to claim these lost items at school. The second person who is basically a beneficiary is actually the child for whom the item was bought. So it's the same thing with the unclaimed financial assets. We have two classes of people who can claim. The first one is the direct owner, the person to whom the item belongs. And God forbid, if that person has passed away, then it would ordinarily be the people who have been identified as beneficiaries under the law of succession. Now, we have dealt with the whole concept. So the whole concept is exactly what you'll find in school. It's a lost and found idea. The item has been lost, it has been found, it is being kept until the owner comes for it. That's the whole essence of unclaimed financial assets. So the mandate of UFA is basically what we have discussed in that photo, which is to receive and claim the assets. And in the beginning, it was only thought that we could only deal with financial instruments, which are financial assets, which are financial in nature. But that may as well extend to land in the future, depending on government policy. So we receive those financial assets, then we safeguard them and then reunite them with their owners. Now, let me just go back to this photo. And now I'll ask another participant to tell us something. Now we have said these kids can donate these items after a certain period of time. But suppose they were to sell these items. What do you think they should do with the money? Would you think there should be a restriction on what they can do with the money? Any duty that should be imposed on them in terms of possibly what they can spend it on? Someone who has an open mic. Any restriction you think the school should impose on them so that they don't sell things for the sake of now getting cash?
And members, we are free to unmute our mics as long as once you are done, you can mute once again. We can also take advantage of the raising hand and also the chat on the side. Thank you.
So someone to volunteer quickly and say something. We have over 80 people here.
And I can see on the chat, someone says that they can help the needy students.
Yes, that's one of the ideas, donation.
Yeah.
Yes, I have seen an answer there that was actually given by Isaac Baraza on the next of kin. So
yeah, it's a recipient.
Yes. So one of the things, because these items don't belong to these trustees. These students are basically trustees, and that's the same thing with UFA. We are trustees. We are guardians of people's items. So we cannot be allowed then to just wake up one day, we say we have corrected this amount of, for instance, shares for people, and we decide to dispose them. There must be some restrictions. And for that, when we deal with cash, all the money that you hear being reported, the 25 billion, it's not our money. It's not government money. It's money that belongs to individuals or to private citizens. And therefore, we are only allowed to invest it in government securities so that we don't engage in risky managerial practices. And the interest that we earn from those investments is what we use to run our operations so that we don't become a burden on the taxpayer. So members, let's now look at the reasons why do people actually abandon their assets. So quickly, I wanted people to tell us, but quickly, can someone tell us why would someone abandon something? Why would someone not claim something that they know is theirs? Watu waseme kitu.
Okay, my name is Masibo.
Masibo, yes.
Yes, I would like to say that maybe someone will not manage to come for it, maybe because there's an issue with the law. Maybe they acquired it in the wrong way. But probably the conflict over the assets.
Yes, Masibo. So the second one, okay, if they had illegally acquired it, then that would be another issue, and that would go possibly through asset recovery authority. But the second one, where there's a conflict, I think I can think of especially family disputes. That's one of the reasons why at times these assets end up with us, because people are unable to agree on who should have the item. So Helen, please.
In a case of one of my relatives, he passed on. Yes. And I just saw his name in the published list on the newspaper. And then the other one went to the US. So they relocated to another country, so they are not able to access.
Those are very good reasons. So thank you, Helen, for those two points. So going straight, that's right. She has said the first one, of course, is dead, as you can see from that photo. The second one is where people have actually possibly given the wrong address. You remember in the some days gone by, my shosho, when she was buying some of these things, the only address she could use, she didn't have a private, her own rental box. So of course, in those days, what used to happen, people would actually use the address of the nearest school, possibly the nearest church. And when things change, then you find that if that, the people who are running that school or that church, if they're no longer there and they don't recognize that name, what happens? That letter ends up being taken back. So you might find somebody's dividend check being sent back as addresses unknown. The other thing is people at times don't keep proper records of the assets. I can see Rilian, you had raised your hand. Lilian, you had raised your hand. Possibly you can say something.
And as Lilian unmutes, I can see also on the chat side, Mwalimu, that someone is saying that the money should be channeled through the school bursar for proper accounting. That's in the case of the students before disbursement to the beneficiaries.
Yes.
And someone is saying why they would not claim, probably is because maybe they don't know how to go about it.
Those are very
they do not know these assets exist, and so they don't know the process of getting these assets. So first of all, are they aware that the assets exist? And then somebody says, Grace Akinyi says, I have always assumed that assets belonging to a deceased and next of kin is not aware, and most people don't know where or how to check. Yeah.
Yes. So we can hear Ririan, then we go on. Ririan had raised her hand.
Lilian, you're able to unmute.
Okay, then let's go on. And then at some point, she can just raise her hand and then we can allow her to speak. So the other reason is, of course, what you have said, poor records. As Akinya had said, at times people don't even know that the asset exists. And most of the times it's because no records were kept by the person who owned the assets. And that's something we can relate to. A lot of people don't, especially generations gone by, they never used to keep some of these records. The other reason is what one of the participants has alluded to, ignorance. And mostly about the process involved in claiming, or even whether there's an institution that deals with these assets. One of the things they are grappling with why people don't claim is when they realize that the item is of very little value. So you find some, for instance, you had a student account, it had 500 shillings. That money, the account has been declared dormant because you have not used it for years. And the bank has sent that 500 to farm. Most people, when they realize that that's all that there is to it, they'll never bother because they just calculate the cost. Even if they're taking an Uber one trip within Nairobi, that's already too much. So you can imagine somebody up country and they realize it's even 3,000, they'll not come for it. So that's one of the challenges we are facing. People don't feel motivated enough when the asset is not of a particularly high value. The other reason is what Masibo had said, family disputes. So participants, going quickly to the act itself in terms of how it presumes the assets to be abandoned. And is usually a function of both time that has lapsed since the owner has possibly dealt with the asset, and also conduct in terms of utilization. So let's look at the presumptions of abandonment in the next slide. So we have classes of assets within the act and the regulations which have been set, and the period within which or after which the asset will be deemed abandoned. So the keyword is that it's deemed abandoned so that the owner can come for it. So for instance, you have the shares and dividends arising from shares. You'll find that 3 years after you fail to cash your dividends, those dividends will be surrendered to UFA together with the shares underlying them. Checks generally are 2 years, and a lot of the items here are 2 years. When it comes to your savings account, or basically bank accounts, it has a longer shelf life, that's 5 years. If there's no activity within 5 years, and you have not been in touch with your bank, or they try to trace you and they can't find you, then they're supposed to turn over whatever there is in the account. Life policies, it's 2 years. If you had put a deposit, for instance, with Kenya Power or any of the utility services, you're given 2 years. If 2 years of no activity and you have not claimed your money from that provider is supposed to hand over the money. And the risk goes on. When it comes to instance things held in a safe deposit box, these are usually held by banks. Within 2 years after the owner has failed to come forward and claim the item, or there is no activity on that particular deposit, the owner has not either been in touch with the bank, and efforts to trace them by the bank have failed, then 2 years later, the bank is supposed to hand over those particular assets. So basically that is it. I wanted just to introduce the concept so that to mark the end of my presentation, and I can now welcome questions. So Irene, the flight is about to take off.
Yeah, thank you. Thank you so much, sir. I think that was basically a good introduction and making us understand the concept behind the, you called it UFA. We like calling it UFAA.
Yes.
Yeah, and I think we are already getting the concept. And one of the questions that was kept coming is why or what kind of properties or assets end up in your custody. And then the other question was then how does an ordinary Kenyan know that they could be having property with you? And then the process of how can they claim the same. I think if you answer those three, I'll also be opening up for any member here who could be having any question that they feel is not tackled by the presentation or by the three questions. So what types or what specific assets are in your custody? How can someone know that they have some assets in your custody, and how can they claim them?
Thank you, Irene, for those questions. So in terms of assets, as I had just displayed, we have classes. So these are basically the classes which we are supposed to safeguard. What is not here is land, for instance, and that is something that is very emotive to Kenyans. So the government decided possibly we don't want to rush into land. And just to mention, for instance, on shares, even when this period of 3 years has lapsed, we don't also rush to take those shares and dispose. The law actually allows us after some time to sell, but we don't rush to sell shares because, as you know, most people actually hold their shares for a longer term than this, and there might be no particular activity, especially if the company issuing those shares is making a loss or has not declared dividends. So we don't usually rush, but we just ask for evidence from the intermediary about whether the owner has been in touch, so that we don't also end up holding people's shares and they have to struggle to come back and try to sell them possibly at a price that is not attractive. But these are the assets classes that we deal with. Basically anything of a financial nature you'll find here. In terms of how you can claim, we have two ways. You can use the website to access the services, and that is www.ufa.go.ke. You just navigate and register yourself. The reason you ask to register is so that we minimize fraud. And once you register, then you can actually search using your name or even ID number. Mostly the name will tell you. A phone number will also assist to narrow down, especially when we have people who have common names or shared names. When you come to claiming, okay, you can also use the USSD, the short code, which is *361#. Then the other way you can claim is in Nairobi, you can go to any of the Huduma centers. We have the 5 that we partnered with last week. So they're also offering the same service. So we have someone at those counters and they can assist you to claim. Now you're required, of course, to basically show that you're the owner of the asset. So any evidence that you might have, for instance, if it was a bank account, you could come with a letter from the bank where you had the account, and we call it a holder's letter. The person holding the asset is called a holder. And that's, for instance, your bank. And they'll give you a letter saying we have surrendered this amount belonging to so and so from this account to FA. Now with that letter, that is basically evidence. Of course, we'll check, but that is evidence. So for that, those are direct owners. We have the other class of people who can claim, and that's basically beneficiaries for people who have passed on. And those ones must come with letters of administration from the courts, a confirmed grant, so that we know that that particular item has been given to you. Then you can claim. I hope I have answered your questions, Irene.
Yes, and progressively, I believe we are continuously getting to understand the why, the how, and everything in between. And I'm seeing Haemba asking, since the reasons for abandonment are known, what is the authority doing to improve service delivery? Has the authority explored the possibilities of paying beneficiaries online? For example, through M-Pesa, once the case has been cleared. And then somebody asked, I think you can handle those together, whether UFA is related with the CDSC. I believe you'd understand that, or Delphine can clarify. And then I think David is asking, or Isaac is asking, you could repeat the SSD code.
Yes.
Maybe you can handle those 3. What is UFA doing to improve on service delivery? Are you related to CDSC? And you could repeat the code for those who would want to check.
Okay, so for the first question, has the authority explored the possibilities of paying beneficiaries online? Okay, this is one of the process improvements we are looking at. Currently, we pay directly to your bank account using either RTGS or DFT. But we are going to move to that platform. We are working on some ICT improvements, and we can actually be able to pay to people's M-Pesa accounts. The other question,
the relationship between UFA and
CDSC. Okay, we are not related as such. Of course, the CDSC is also a state corporation, but actually CDSC is one of the people we work with in regard to issued securities on the stock market. So these are one of the stakeholders we work with to ensure that we deliver on our mandate, especially on shares and dividends.
Mm.
So the short code is *361#. Someone asked.
*361#.
Yes, *361#. The other question is why? Yes. The other question is why does one need a lawyer stamp to access the property? Why not just an ID? That was asked by Delphine Logan. Okay, the reason is when you are coming with the copies of the documents, usually you are required, for instance, to get a lawyer to certify that those documents are authentic, they're genuine, just to deal with the issue of fraud. But on our side, we also partner with government institutions, the registrar of persons, to check your ID. Because if you came with just an ID, in this country, there are people who have been inventive enough to manufacture the older generation IDs. The current ones, we haven't found a fake one, but we have had a case of actually a genuine case of a grandson who came claiming using his grandfather's ID, and the grandfather had died. But because the names were similar, actually the 3 names were the same, it's just the order. So we don't just rely on the ID, we have to check. If you're using letters of administration, we actually visit the court and check ourselves to verify, just to ensure that we don't pay out to the wrong people. Yes, the process at times might be a bit laborious, but it's for good reason that we don't also let people just claim and end up with cases where somebody is accessing money they are not entitled to. The other reason, for instance, we have cases of people with foreign passports, because we have people, Kenyans, who have gone outside the country. Some have multiple nationalities, dual nationalities, and you might find somebody has a foreign passport. So that also becomes an issue in terms of we have to go to the embassy in Kenya where you have been issued that passport, for the country you have been issued that passport, for us just to confirm. Because the risk of us paying, for instance, money to a foreign account, chances of getting it back are slim. So we just have to be cautious. So far, we haven't lost money, but we also robbing government to relax, for instance, based on value, because we are feeling that if somebody is claiming below 5,000, perhaps we can remove some of the requirements. If you come with for instance, if it was a bank account, if you come with the ID, the original debit or ATM card or credit card for that account and the original statement, we have a relationship with the bank, we can check. So we are working on some improvements, but that will also mean government has to change the law and some of the policies it has put in place to ring fence unclaimed assets. So I hope I've shed light on that. So I'll not answer the question of the process of getting a letter of administration. I'll possibly leave that to another presenter. So the person, Helen, who has asked about where the relative died and left no will, so you have to go to court and get letters of administration. So in terms of someone has asked why we have not created a lot of awareness, we're actually running a campaign both on the social media platforms. Since last week, we had an event where we launched our services with Huduma Kenya, and that was last week. And that is something that we do. You may not have seen. You remember the one about pengine uko umesota na hujui, umeomoka na hujui. That was also one of the messages. So at times people don't realize that it's actually fast that we are discussing in those particular advertisements. But yes, we are working on increasing the awareness. So I think I've answered the questions. We don't deal with cryptocurrency because as far as we are concerned, we have not even come across an unclaimed asset in that particular form for now. Kelvin Irongo is the one who had asked. So that's the end of the questions.
Yeah, I think I would want us to leave it at that for now, Bwana David. And members, I think questions keep coming. And once again, we always promise that once they come to us, we always are able to respond. And when we are not, we're able to seek for answers from the experts and those that are responsible. But I want to take this opportunity once again to thank you so much, Bwana David, for creating time to come and create awareness. I like the question that LA is asking, why you have not created awareness, considering that this is a matter of national interest. But I think even such a platform is a good step towards the right direction. And I believe we should have more of such forums so that people are aware. Somebody was saying, of course, he says that there are children suffering out here due to loss of a breadwinner, yet surviving spouse might not know something, that they have something out there. And my friends, I think this is one of the reasons, key reasons actually, as to why we are here, that we have properties here and there. We have not aware, and people don't know, or nobody knows of what we own. And especially being Kenyans, I've interacted with many of us in matters relating to financial assets. And one of the things that actually pushed me to host such a program is where somebody acquires a property and they don't want the spouse to know. They don't, of course, the children probably are young, even if they knew there's nothing much they can do with them. And as nature will take its course, you find somebody has passed on and they have so much property, but the family that is left behind have no idea that they were left with such property. There are issues to do with trust, and like David has said, I think we one key thing, besides knowing that we are here where we are, we have an unclaimed financial or assets that we don't even know they exist. Most importantly is to inform ourselves of how do we prevent this from happening. And I think that is going to take us to the core of this discussion. And members, at this rate, I was keen to see if we are going to handle all the 5 topical areas that we had highlighted. And if this doesn't happen, I promise that we can also have another session to ensure that we exhaust or we handle this exhaustively. So at this particular time, so that we are able to deal with this matter from a preventive measure, I said once again, we are honored to have on board Gikera and Badgama, a law firm that is doing great things in this area. They would be able to tell us, of course, how to get the letter of administration, but most importantly, how do we ensure? If you checked on our social media platforms, we were saying, how can we ensure that the properties that we acquire live for our generations and that they don't have to live not knowing that they existed or not being helped by the same. As we prepare for Gikera to present, to share her screen and also introduce herself, I want also to check on the chat. Somebody said, I once benefited when my name appeared in the paper, and that is part of creating awareness. We also have, I personally have seen my assets listed, but the value versus the process of claiming is too difficult and decided to abandon. And that confirms what Bwana David was talking about. And then somebody says, Mkaemba, thanks David for sharing insightful information. And we always say, once you have received information, then let's be ambassadors. That we are here, I think almost 100 of us, I believe we could reach out to one person each, and we can be able to share with them this information. Bwana David, once again, on the chats, we would appreciate if you could probably type for us the USSD SSD code, so that it's written, so that we know how can we check. And now, Bwana David, thank you so much. I pray that you will still be with us through the process, so that in case also there are other questions, you would help us to respond to them. With us is Madam Annette K. Kwamboka Akama. Allow me to mention your full name now that I was not able to do that on the flyer because it's a long name. And I want to take this opportunity once again to appreciate your organization, Gikera and Badgama, for acknowledging or appreciating to accepting to be with us as we deal with such weighty matters. So, Madam Annette, karibu sana. Feel free to tell us what you have for us. I think we will handle, I think, 1 to 3, and I'm foreseeing, so that we do justice to this. We are likely to end with your presentation, and then we will be dealing with the issues to do with dispute resolution and others in a different platform. But thank you so much, and karibu sana.
Thank you so much, Irene, for having me, and I thank you for this collaboration as well. I don't know if you can see my screen.
Yes, we can.
Yes, it's
all right.
visible.
Are you also able to see me as well?
Yes, we can see you.
All right, I think I'll leave my video on because I think I find it more interactive this way, because then you're able to see who is presenting. So thank you so much. My name is Annette Akama. I'm from Gikera and Badgama Advocates. Irene and Hallmark invited me to make this presentation on legal aspects of matrimonial property in Kenya. I'm glad to be presenting on this because, at least in this forum, I can tell it's a life skills forum from what Irene said. And it's good to talk about social issues of the law in an informal platform like this, but still be able to build your capacity and give you enough information to protect yourself and your property in the course and the subsistence of a marriage. So thank you, and I will begin my presentation. So matrimonial property is property that is acquired during the subsistence or the duration of a marriage. And the law in itself is, and the state is interested in the welfare of people in marriages, in unions, because remember, in these unions we have vulnerable people, vulnerable categories of people who are children, and sometimes even women, when it comes to things like property rights, and we know how culturally women's property rights have always been undermined. So the law holistically usually has an interest in the social unit of society, and without being too intrusive, it will want to protect the interests of vulnerable people in the smallest unit of society, which is the family. So that is why we have different acts, different laws protecting this unit of the family in different aspects, such as children's right in the Children's Act. Then we have the Marriage Act and the rights of parties to a marriage. Then we have the Principal Act that we're going to be discussing today, which is the Matrimonial Property Act. So it's a very interesting way to look at the law and how the state is very interested in protecting your interests and my interests within our families, as small or as large as they may be. So matrimonial property is first of all regulated and set out in the Constitution of Kenya. Then we have the Matrimonial Property Act that I'm going to discuss today. We have the Marriage Act number 4 of 2014, which basically provides for all the avenues of getting married in Kenya. It could be customary, it could be religious, whatever avenue of marriage it is provided under the act, and how a party's rights are protected under that marriage. Additionally, how to enter into that marriage and how to get out of it. Then we have the Law of Succession Act, Cap 160, which is a bit of an older act compared to the Matrimonial Property Act and the Marriage Act. This act basically provides for how a deceased person's property is taken care of, administered, distributed long after they are gone. Then we have the Land Act and the Land Registration Act, because remember the principal property that we're going to be discussing, the principal form of property that we're going to be discussing during this session is real estate, that is land, property in the form of land, because that is what, in Africa, land is very emotive. There's an emotional connection. The land question in Africa, in Kenya, is very personal. And usually we count ourselves as having succeeded when we have first bought up, when we have bought our first piece of property. You know, I have a shamba somewhere, regardless of how small it is. It could be a quarter or an eighth of an acre. So land, of course, is usually the principal form of property and property acquisition in Kenya. And that is why I've included these two acts, the Land Act and the Land Registration Act, in terms of covering what matrimonial property is. So I'll start with the Constitution of Kenya. I'm a lawyer, so you'll have to pardon me. I'll have to go through the regulatory framework. And because I just can't advise you from the top of my head, I will keep on referring to what the law provides, but I'll try and make it as social and as interactive as possible. So we start from the Constitution of Kenya, which is basically the grand norm, something we call the grand norm in law, and that is basically the source from where all our laws emanate. And Article 40 of the Constitution provides for your right to own property as an individual in Kenya and outside. And Article 40 further goes to say that Parliament cannot enact laws that arbitrarily deprive you of your right to obtain property. So it is well within your right to obtain property if you want to. And then Article 45 of the Constitution goes a step further to say you, as an adult, have a right to marry a person of the opposite sex as long as it's consented by both of you. Free consent to get married. So that right has been provided for in the Constitution. And the Constitution provides that in this marriage, you have equal rights before, during, and after that marriage, both husband and wife. And the Constitution goes a step further to acknowledge the family as the most basic unit and the most basic function and form of society. And so the family then has to be protected. And if you look at the Constitution, it says that the state will do what it needs to do to protect the family. And that is where we will now start our conversation in terms of matrimonial property within this context of the family and the marriage. So I'll move on to the next act that I covered, and which will form the basis of our discussion today, which is the Matrimonial Property Act, because rightfully we're discussing issues to do with matrimonial property. So this was an act that was actually passed very recently on 24th December 2013, and it came into commencement on 16th January 2014. So you may ask yourself what was happening previously. So we had something that was called the Married Women's Property Act from England that we used to rely on because we didn't have any substantive regulation that covered property rights and specifically property rights for women in marriage. Then we had the Marriage Act and the Law of Succession Act and the Constitution, which we sort of drew from to be able to provide for them, or rather seek information and seek legal guidance in terms of the protection of property obtained during marriage, especially for women. But now we have the Matrimonial Property Act that was enacted in 2014, which then takes into account the interests of both parties during the subsistence of a marriage and after. And you'll see down here that I've set out that the purpose of the act, as set out in the act itself, is to provide for the rights and responsibilities of a spouse in relation to matrimonial property and connected purposes. So what are the key provisions of the act? The act has defined what matrimonial property is, because as I interact with people, it's evident that there is a sort of dissonance and misunderstanding of what matrimonial property is. But the act has defined it, and we look at that. Then it also sets out the right of the spouses and the property that have acquired during the subsistence of a marriage. So it's your right vis-a-vis this property that you and your husband have acquired during this marriage, or you and your wife. Then ownership of matrimonial property. Remember, when a marriage or when a relationship is good, it's good. And when it's bad, it's also very bad, unfortunately. And so the law usually comes in, and that's why we have the law, to protect people's interests when things inevitably go awry, to a point where it cannot be salvaged and that marriage has to end. Then the act also provides for property rights in polygamous marriages, because remember, the law now recognizes under the Marriage Act customary marriages, and most customary dispensations allow for polygamy. So what are the rights of women and a man in a polygamous sort of union? Then also spousal liability for property acquired before and during the marriage. Remember, it is through our property that we build our credit, that we get loans, that we get financing. But then when everything goes awry, who's in charge of those loans that we were both happily taking during the marriage? Then the extent and the application of customary law in property division. Remember, not everyone will go before the AG to get married. Not everyone will go before a church. Other people will get married, have their ratio, will have their coito, and that is sufficient now. That is a marriage for all intents and purposes under the law, and you have to register it. But remember, when things go awry, you will go back to the elders, or you will follow the procedure of trying to arrive at an amicable settlement using that customary law. And when that doesn't work out, our customary and traditional dispensations then provide for ways in which we can part ways. So what's the extent of the application of customary law? Because remember, we come from traditions that were inadvertently very unjust to women. So to what extent do we apply them when we're trying to resolve matrimonial property disputes? And then basically disposal of interest in matrimonial property by spouses. So that means when you're in a marriage, you can acquire a property, you can sell it, you can get a loan against it, you can charge it, you can lease it. So how do you protect your rights when you're basically exercising your interest in this property by either selling, leasing, or acquiring a loan and charging this property? So those are basically the key provisions of the Act. I will now proceed to cover the key concepts, basically what you need to know about this Act. So number one, what is matrimonial property? And the Act sets out that matrimonial property is a matrimonial home or homes. So the house that you're living in with your spouse, that's matrimonial. That is a matrimonial home, and that is matrimonial property. Then additionally, the household goods and effects in that home or in that house. So the furniture, the fixtures, the sofas, the Tupperware, the linenware, all that is matrimonial property. then any other immovable and movable property jointly owned and acquired during the subsistence of their marriage. So section 6 of the Act sets out what matrimonial property is. And whenever a dispute arises and it becomes litigious and it is taken to court, the person who's deciding this case, that is the judge, will always go back to section 6 and see this property that this couple is arguing. Is it a matrimonial home? Or is it household goods in that matrimonial home? Or is it any movable or immovable property that was jointly owned and acquired, and the keyword being jointly owned and acquired during the subsistence of their marriage? Over the years, there's also been dispute and conflict as to what a matrimonial home is. And the Act then came in to define what a matrimonial home is. So it's property that is owned or leased by one or both spouses and utilized as the family home. So it's basically the property that is used as a family home. Remember, there's some very well-to-do families that have many homes, and they have a holiday home in Nanyuki, they have a holiday home in Mombasa, but is that where you permanently and consistently stay and utilize that space as a family home? Not necessarily. So where your residence is, where your home is, that is what a matrimonial home is, and it forms part of matrimonial property. The Act has also been clear to exclude certain properties from matrimonial property. So trust property and inherited property. If I inherited property from my father or from my mother, that property will not form part of matrimonial property. And then property acquired before marriage. The property that I bought when I was a spinster, I'm using the legal word spinster, being a woman who's not married, that property is mine. It is not matrimonial property. Unless I then take the steps under the Land Act to then get my husband and register him as a joint proprietor in this property so that we become owners on the title, both of us. If I acquired that property before my marriage and I have not in any way included my husband in it legally, that property is my property and it's not part of matrimonial property. Then the Matrimonial Property Act is also, it's bringing in very modern concepts to a very African setting. And it sets out that parties can enter into an agreement before marriage to determine the property rights during that marriage. And these are prenuptial agreements. You know, in Africa, we dread thinking of the worst. And that is why we are not so good at drafting wills. We think that if we draft a will at this point, we are drawing death closer. And in the same way, before we get married, we shudder at the thought of sitting down with our partners and drafting a prenuptial agreement as to what our property rights will be in this marriage. But it's a very clean way of entering into a marriage. And from my experience, it fosters trust, because then you don't have to worry too much about what is the place of my property that I came with in this marriage, what will happen with the property that we both acquire. I mean, as much as the law is providing for this, you can supplement in this agreement your rights by mutually arriving at provisions that are beneficial to both of you as the husband and the wife, so that going forward in that marriage, you're very clear, this property is mine, this property is yours, this property forms part of matrimonial property, and in the case we divorce, this is what will happen to this property, you know. And even in prenuptial agreements, you throw in things like, if I am, for example, unwell, I want my family to have free access and passage to me. You even provide on what should happen when you die, where you want to be married. You make it very clean, neat, and seamless, so that when you're gone, or even in a situation where you guys have split up and you're unable to repair your issues and you divorce, it is very clean. It is very easy. You go back to that agreement and that you say, this is what we agreed. However, these agreements can be held void if they were seen to have been drafted under coercion or if they are manifestly unjust. So the court will always uphold a prenuptial agreement to the extent that it's not unjust and that both parties freely agreed to it. So it's something we should consider, because the law has provided for it, then we should take advantage of it and we should not be afraid. So when it comes to matrimonial property, it vests in the spouses according to contribution of either spouse towards its acquisition. So it's not enough for me to come and say that this property right here, it was acquired when I was married, therefore it's matrimonial property. The court now requires a claiming party, a spouse, to demonstrate that they contributed to the acquisition of that property, and the extent to which they contributed will determine the extent of their rightful claim to that property. And contribution is both monetary and it's non-monetary. And the Matrimonial Property Act has set out that domestic work and management of a matrimonial home is contribution to that home, and therefore you have a stake based on the cleaning, the cooking you did, the taking care of children. We are now starting to understand that these reproductive roles that women play are actual contributions to the welfare of the family and to the matrimonial home, and therefore it segments your claim to this property. If you are offering companionship to your spouse, you are offering them the requisite mental, spiritual support that they needed to carry out the activities to succeed. That is contribution to the property that you both acquired. If you are managing a family business or a property for the benefit of the family, that is contribution. And even the farm work that you're doing, kitchen gardens you have, or you're farming for the interest of the family, either to sell or for purposes of subsistence, that is still contribution. And I'm so grateful for this provision and for this clarity that the Act has brought out. Because remember that in Africa, traditionally, women had to stay home to take care of children. And even right now, for us women, we have stepped out of the home and we are still working. But remember, the burden of childcare is still unevenly placed on us. So it's not enough to come and say that she hired a nanny, she was working a full-time job, therefore she cannot say that she was not doing domestic work and she was not managing the matrimonial home. As much as I've hired a nanny, still the principal responsibility of ensuring that children are well fed, that the house is clean, that the children are okay, and that they're healthy still lays squarely on the wife, and it's still contribution. So for me, I feel that this is a very encouraging and positive way of acknowledging the contribution that child-caring spouses, and mostly women, provide to unions. The Act has also provided for equal status of spouses, and it has specifically addressed itself to women. A married woman has the same right as a married man to acquire, administer, hold, control, use, and dispose of property, whether movable or removable. As women, we have the right to enter into a contract and to sue people and to be sued in our own name. So equal property rights under the Constitution have now been brought alive under the Matrimonial Property Act, that women can now hold property. And any provision in customary law that is against this or does not support this is repugnant to justice, because now women can own property. And it's not a ground. You cannot say that our custom then says that women cannot own property, therefore you exclude women. No. This provision has enabled us to rightfully, under the Constitution and under this Act, to own property. So what about people in polygamous marriages? Remember, we come from a diverse country. We have diverse cultures. We have even diverse religions that then make it possible for people to be in polygamous marriages. But remember, in a polygamous marriage, the inherent risk of your rights as a woman specifically also, because usually it's women in polygamous marriages who find themselves at the higher end of risk in terms of losing property that you rightfully contributed to, or your children missing out, because there are many of you, there are multiple wives, and so the interest is larger because the people having claim to this property are more. So this is what the Matrimonial Property Act provides for. Property acquired by a man and his first wife before he got another wife, that property will always be deemed to belong to the man and the first wife equally. Then, if he gets another wife, possibly another one, and now there are three, the property acquired after he gets the subsequent wives, or the subsequent wife, shall be regarded as owned by the man and all the wives, taking into account each of their contributions to that property. However, sometimes they can contract out of this by agreement. And so the third wife and their husband could actually have contributed exclusively, both of them, to a property. they can then say that this property that both of us contributed to, we want to exclude it from matrimonial property, and effectively then the man and the third wife will have exclusive interest to that property against all the others. So the other wives would have a claim. But this is where it's done clearly in the way of agreement. So now people who, our Muslim brothers and sisters may find themselves covered under this provision, but remember the simultaneous provisions under Islamic law, and also in a situation where a person dies and how their property is then distributed. We have the whole Waqf process. I think it's called Waqf, W-A-K-F. So they can choose to either rely on this, but they can also have the option of following the procedure under Islamic law in all matters relating to matrimonial property. But in other marriages, for example, now customary marriages where the polygamous marriages, this formula is what will be followed in determining property rights. So there's also that issue of spousal liability. I realize that we are actually 98 or 99 people in this Zoom. And it's possible that there could be people in this Zoom, or there could be 1 or 2 people who are actually contemplating leaving a marriage, which is sad, but it's a reality. There could be someone contemplating leaving a marriage. And depending on how long you've been there and how active you are in terms of making investments, taking loans, incurring liabilities, eventually for the benefit of the family, you may be thinking and doing the math in your head, how am I going to exit this way as cleanly as possible and with the least liability to me? So liability incurred before the marriage remains the liability of the spouse who incurred it. For example, if I meet a man today and he has a beautiful house, but he has charged that property, he took a loan against that house. We get married and that house becomes our matrimonial home. And remember now, there's still a charge subsisting over that property. What if we divorce? Will I become liable for that loan that was taken over that house? So the law is clear that liability incurred before the marriage in respect to that property, it remains a liability of the spouse who incurred it. So in this situation, it will now be my ex-husband's liability because it was incurred before the marriage. However, the Act proceeds to say that any liability that was reasonably and justifiably incurred, if that property becomes matrimonial property, be equally shared by the spouses unless they otherwise agree. So over here for me, I have seen 2 conflicting provisions. You see, the first provision is saying liability incurred before marriage lies squarely on the spouse who incurred that liability. Then now the Act goes forth to say that property becomes matrimonial property, but it was reasonably and justifiably incurred by the spouses. It shall be equally borne by the spouses unless both of them disagree, or unless they agree otherwise. So for me, I sort of see some sort of dissonance between these 2 provisions under the Act. But if we go a step further, the law says that spouses shall share equally any liability incurred during the subsistence of the marriage for the benefit of the marriage. So there's a difference over here between those personal loans, like you're just taking a KCB, a pesa for 5K to fuel or to do something, and loans that are actually taken, or securities and facilities that are taken for the benefit of the family, for example, starting a family business or buying a family property. In this case, the spouses shall share the liability equally if that liability was incurred for the benefit of the marriage during that marriage. And then any reasonable and justifiable expense incurred again for the benefit of the marriage. So when we look here, it's trying to look at the sort and the nature of the liability incurred. Was it for personal gain, or was it for the benefit of the marriage and the family? So if it was for the benefit of the marriage and the benefit of the family, both spouses will then incur equal liability, or will incur joint liability over that particular claim in respect to that property, matrimonial property. So if you've taken a charge against the family home for the benefit of the marriage, then that loan will be borne by both the husband and the wife. But if it's a personal loan that doesn't have anything to do with matrimonial property, and remember we have quantified what we have indicated what matrimonial property is. So if it's for a property that doesn't consist matrimonial property, then the spouse that incur that loan will be liable for it on their own. Is customary law considered in the division of matrimonial property? Remember, you may be a person who was married under customary law. So you only had a ratio and didn't do anything further. You only had a coito, or for a kisia, I think it's called the ekeragirio. That is what you did, and that was the marriage, and you stopped it at there. That is a customary marriage. Now, when you're divorcing, you will follow the procedure under customary law. But now the question is to what extent? Because like I said before, customary law sometimes, or customary traditions, had provisions that were repugnant to the interest of mostly women and sometimes children. So the law will consider customary law, yes, relating to divorce or dissolution of marriage, but it will also consider the principle of protection of rights of future generations, meaning children, to the community, and also ancestral land as provided for in the Constitution. Again, it will also consider the principles relating to access and utilization of ancestral land and the cultural home by a wife or wives or a former wife. So basically over here, the law will try and look at the interests of the children, the interest of the community, and the interest of a wife when it comes to customary law, because we know these are the two people, children and women, who are usually disadvantaged under customary law. So to the extent that the application of customary law will not be repugnant to the provisions of the Constitution, and that the rights of women and children are then taken care of, it will be applied. So I will now move on to spousal consent and protection of interest in matrimonial property. Remember, in the course of the marriage, you will acquire property, you will want to sell it for a profit, you will want to obtain a loan over it, you'll even want to lease a portion of the premises or the entire premises of the property. But remember, the law wants to ensure that because this is matrimonial property, there's equal, there's knowledge by both spouses of the intention to either sell, transfer, charge, or lease this property, and that both spouses were involved, and that the only way you can do this is to get consent, spousal consent. So the Matrimonial Property Act is clear that you cannot dispense with an interest in a property by sale, by leasing, by mortgaging, or in any other way without getting the consent of your spouse. And this is specific to a monogamous marriage. So in my day-to-day practice, because I double down in real estate and conveyancing as well, so usually when I'm acting, for example, a financier, a bank, the bank will want me to ensure that before they give a loan to a borrower, that I procure, or in the charge document that I'm going to draft on behalf of the bank, that over there I have obtained an affidavit of marriage setting out the marital status of this person taking the loan. And if they're married, additionally, I go a step ahead and procure spousal consent from this person's spouse, or better half, basically indicating that they agree to their spouse getting a loan on this property, or if it's going to be sold, that they agree to this property being sold. And under the Land Act, it used to be an overriding interest until 2016. Spousal consent was an overriding interest, meaning that if a spouse did not consent to a property being charged or being sold, the transaction itself could be held voidable by reason that this consent wasn't obtained. But that was until 2016. Now there was an amendment to the Land Act, and it's no longer an overriding interest, meaning a transaction won't be held to be void just because a spouse wasn't notified or they didn't give consent. But still, they can have a claim to that property by virtue of the fact that it was matrimonial property and they had an interest, either registered or beneficial, and they should have had a say before the transaction. So for good measure, for all transactions relating to married people, this property could possibly be matrimonial property, and to be on the safe side, we always procure an affidavit of marriage and spousal consent to this transaction. Remember that in the duration of a marriage, things go awry and people may split up. And we have seen the unfortunate cases where you are evicted from your matrimonial home. A party is evicted from their matrimonial home. And unfortunately, in most cases, it's usually women. So the Matrimonial Property Act has come to secure and to remedy this. And it provides that a spouse during the subsistence of a marriage will not be evicted from their home except one, by an order of the court, or on the execution of a decree by the court again, by a trustee in bankruptcy, and this is a court or a bank or a court-appointed trustee, or an insolvency practitioner who has been appointed rightfully with the approval of the court, or by a charge in the exercise of power of sale. So effectively, a husband who has disagreed with his wife cannot wake up and go with goons to dispossess her of the matrimonial home and throw her out. He cannot do it because this provision provides that that can only be done with the involvement of the court or by a charge exercising the power of sale, and that is a bank selling their property. Then a matrimonial home shall not be mortgaged or leased without the informed consent of both spouses. So I'll move on. Then there's the issue of separate property of spouses. Basically, any property that you acquired before the marriage does not form matrimonial property unless it's agreed otherwise. And marriage does not affect the ownership of property other than matrimonial property. So if it's not matrimonial property, it doesn't fall under the provisions under this act, and therefore marriage will not affect it in any way. Then there are certain presumptions that are made regarding property during the subsistence of a marriage. So if I'm married and my husband acquires a property in his name only, there's still a presumption under the law that he's holding that property in trust for me as well, as much as my name doesn't appear on the title deed. And then if we own the property jointly, and it's very evident in the title that it's me and him who own that property, it is still presumed that we own it jointly and that we have equal shares in that property. So those are the presumptions that are made under the Matrimonial Property Act. Then also there could be a point where my husband gifts me a property. If my husband gifts me a property and tells me, my wife, take this property free of charge, the consideration is love and affection. That gift of that property essentially then becomes mine and stops becoming matrimonial property. So that in case I die before my husband, that property will not be considered to be matrimonial property in which he has an interest. Instead, it will fall into my estate and it will be administered depending on my will or by my administrators if I don't leave a will. Like I said, there's no liability for pre-existing deaths of a spouse. So a spouse is not liable because of marriage for any personal debt contracted by other spouse prior to the marriage. So if you came with your own loans to the marriage, Polesana, you're liable for those. Irene also asked me to cover the issue of common versus joint ownership of property, and this might get a bit technical. So this is common and joint ownership of property. It's a function of common law. It's not provided in the Matrimonial Property Act. But there are two ways in which multiple parties can own a property. My husband and I can own property together, either as joint owners or as tenants in common. Now, the fundamental difference between joint owners and tenants in common is that as joint owners, we have something called the rule of survivorship. So that if I die, my husband survives me and he then assumes my interest in the property. But when we are holding, yes?
Yeah, I think I feel it's important we seek the consent of members that we are going to extend a bit. It's already 9:30.
I'm almost done. Just one more slide.
Okay, good. And because I realize actually there's one area that you will not be able to cover. It's actually getting more interesting. I'm wondering how we are going to end this. But members, I think we just hold for about 10 minutes, 15. There's actually a lineup of questions for you. So okay. Once you're done with this bit, we will handle the questions, and true to my promise, we will have to do this another day. But thank you so much. It's so enlightening. I am wondering how we would have done Akesha here.
That's all right.
Remember, let's tighten our belts. Let's do this one about the ownership, and then we'll handle the questions, and then I'll give guidance on way forward.
Yes.
Thank you.
Yes, so joint ownership, I've said, is why if I die, my husband survives me and he assumes absolute interest over the property. But when it comes to common ownership in common tenancy, survivorship does not apply. So when I die, my husband will maintain his 40 or 50% in the property, and then my share will fall back in my estate, and the people I've nominated as my beneficiaries, either my kids, my mom, as my sister, will benefit from that property. Irene wanted me to discuss whether it's advisable to go for common or joint ownership. But the truth is, it just depends on your needs as a family and what you want as partners. So for example, if I'm owning this property with my husband, but I want that if I should die, the interests of my children are taken care of. Or say, for example, I got children, not with my husband, with another person, and I come and I'm now married to my husband, but I don't trust him enough to take care of my kids when I'm away. I might opt for common ownership of property so that when I die, my share in this property will fall back to my children. But if it's a property, for example, for a business that we are both running, and if anything should happen to me, I'd want my husband to continue with it. So if I die, we'll probably go for joint ownership, because if I pass on, he can absorb my interest in the property and proceed with it. So it's basically a function of deciding between both parties what you would want. But under the law, the presumption will always be, unless proven otherwise, that where you're acquiring property, you're acquiring it jointly. You're acquiring it jointly. So if you die, your husband will always be your survivor. That's the presumption in law. Unless you agree that we are going to be tenants in common, and even in the title, you will set out that we are tenants in common, 50% for my husband, 50% interest for me. But in the absence of that, the presumption is that you jointly own that property, and the survivorship principle will then kick in. If one spouse dies, the other one automatically absorbs their interest. So what are you going to take away from this presentation? What do you really need to take away or to remember? If you forget anything else, at least you can remember these things, these 5 things. That property acquired during the subsistence of a marriage, unless otherwise provided, will always be matrimonial property. Property acquired before the marriage does not fall under matrimonial property unless otherwise agreed. Where property is acquired in the name of one spouse, it is presumed that it's held in trust for the other spouse unless otherwise stated. So if my husband buys a property, it's presumed that he's also bought it for me as well. So I have a beneficial interest. Then property acquired during a marriage is presumed to be owned jointly, like I said, in equal shares unless otherwise provided, so it's 50-50. Then it's advisable for spouses to enter into agreements before a marriage to determine their property rights for the avoidance of doubt. So that's it from me, team. Irene, I'll take it back to you, and I hope this has been informative.
Wow, what a marathon. I think we took off and really took off. I'm even wondering how to end this. I can see LA saying please continue up to 10 p.m. and I think that's where we are definitely headed to. And thank you so much, Annette. That is so informative, and I'm seeing people are getting their solutions right here. We will be sending invoices to some of them.
Yes.
But thank you so much. This is so informative, and I think so many of the questions that had come through the forms that you guys filled are already being answered. But on a very basic, let me start from a very basic question where somebody said, of course, Annette will definitely speak legal language as if it's basic English, or if you're a kissy like her, she would assume you understand that. She's talking of ratio, and I don't know the other one that she used for the same. But somebody, Annette, just simply asked, you mentioned two ones that they would really want to understand from an unlearned friend perspective, because this is legal terminologies. And somebody says you mentioned something to do with the prenuptial agreement. Yes. And then you also mentioned the aspect of charging a property. Those ones, they sound like they're basic English words, but they definitely have a legal meaning. So if you could clarify on basically those two, a prenuptial agreement and charging of a property, and then we will pick some more questions. And members, you can keep them coming, keep the questions coming.
Okay, thank you so much, Irene, for that. So a prenuptial agreement, what are nuptials? Nuptials are basically the vows you take during your marriage. Nuptials is basically a marriage. So a prenuptial agreement is basically an agreement that you enter into before a marriage, and it could cover a wide array of things. Most importantly, or what most people actually usually concerned about in the prenuptial agreement, most people will cover issues of property. Most issues will come. Most people will want to cover how, for example, income from properties will be dealt with. most people will want to cover how those properties will be split and what money and what property will go to who if the people split or if they divorce. And then it also covers things like, for example, what happens when I die, where will I be buried, and things like that. It's basically trying, a prenuptial agreement tries to foresee possible things that could bring complexities into the marriage, specifically where property and money is involved during the marriage and after, where people separate or where they decide to divorce. So it's basically an agreement determining the rights and the conduct of the parties in respect to their properties, the ones that they're coming into the marriage with, the ones they're acquiring, and what should happen to their money and their property when they pass on. So a prenuptial agreement is just a name that is usually given to this sort of agreement. But what's important is to go back to the act and see that the act basically says that the parties to an intended marriage may enter into an agreement before their marriage to determine their property rights. So whatever name you give it to it, as long as it's an agreement that's providing for property rights, it's enforceable under the act and it's enforceable in our courts. People give it different names. The most common one is a prenuptial agreement. The Matrimonial Property Act doesn't call it a prenuptial agreement. It just basically refers to it as an agreement that determines property rights during the subsistence of a marriage. So that's what a prenuptial agreement basically is. Names are usually given loosely here and there, the most common being a prenuptial agreement. But to answer your question and referring back to what the law provides, it's an agreement that then determines spouses' property rights during the subsistence of a marriage and what happens in the event that they don't stay together forever. Then the word charge. Back in the day, we used to use the word mortgage, which is the most common term that is mostly understood by people. When you take a loan and use your house or a property as security, you're using it as a mortgage. But under the current Land Act, the correct terminology is a charge. And when you're charging a property, basically, is where you approach a financier and you tell them that I need this certain amount of money. And the financier will tell you, do you have any security? Do you have any property that I can use to secure myself? And I will tell them, yes, I have a matrimonial home that is, say, worth 20 million shillings. So this matrimonial home, if the financier is satisfied that the value of the property is actually 20 million shillings, and that if I default, they can sell my property and recoup what they gave me from this property through its sale, they will then charge the property. And how do you charge a property? You execute a legal instrument under the Land Act that is called a charge. And a charge is an instrument basically securing an interest in property, especially where a third party is involved, for example, a bank or a SACCO, or basically a person who's lent you money and they're not the owner of the property, but they have an interest in that property. So a charge will be prepared, then both parties will execute, the lender and the owner of the property. Then this charge will be registered against the title of the property, and this is what we call an encumbrance. So basically, when this charge is registered, I cannot do anything without notifying the bank or the lender, because now they have a registered interest in this property, and that is what we call the charge. So the charge is basically a legal instrument securing an interest, and most times a commercial interest, of a third party over a property. That's what a charge is. I hope that answers the question to whoever asked it.
Wow, very, very interesting. And I think we are also being pushed to become learned friends at a point, and we appreciate that. And then there are a few other questions I think that we can handle before we call it a session. And somebody says, let me leave this question here, even as you present. I acquired a property, that is a house, as a spinster. After marriage, we found it favorable to live in the house. And then he had built a house in his upcountry home, and we considered this our home. In case of divorce, which property will be considered a matrimonial home? And does the woman which house will be considered a matrimonial home, and does the woman have any rights to the rural home, and does the man have rights to the city house? The lady had a house which they call the city home, and the man had a house in the village that they call the village home. What are the rights? And I think that would have come out through the presentation, but you can just touch on that quickly, Annette.
So thank you for that question. Remember, when we were looking through the definition of a matrimonial home, it is basically, and I think I can try and go back to the slides. If not, I can just refer back to the regulations, or rather the Act. The Act defines a matrimonial home as any property that is owned by one or both spouses and is occupied or utilized by spouses as their family home. So there you have it. You see, this property was what you acquired as a spinster. So you own it. It's owned by you as one spouse. But it's occupied and it's utilized as a family home. So in this regard, it is matrimonial property. And both of you then have an interest in this property. Another provision in this Act, I think I forgot to mention it. For example, if you acquired this property as a spinster and your husband then moved in and you found it fit to live there, and let's say he saw, oh, maybe we need to replace the roof, he catered for that, he replaced the tiles, he reworked the plumbing. He effectively then invested in this property, and by virtue of this, he has contributed to that property. He has a beneficial interest. But that aside, to just answer your question, that property as you have described it is a matrimonial home. As much as it's owned by you as a registered owner, it is occupied and utilized by you as your husband, as the family home. And remember, a matrimonial home does not only have to be one, it could be homes, matrimonial homes, as long as it's owned by either one or both spouses and it's utilized as your family home up country. Now, the threshold under case law in terms of what then amounts to utilization of that space as a family home, it's how frequently and who lives there, first of all, how frequently and how long you spend there to justify it being a utilized property as a family home. So if it's a property in Nanyuki that you only go, let's say, once a year, it has been argued in certain cases that that does not necessarily form matrimonial property, a matrimonial home, because are you occupying it and are you utilizing it consistently with the family? I think you'll just have to look at your own arrangement regarding that house up country to determine whether it's a matrimonial home, depending on the use and utilization by the spouses and by the family. However, it will be matrimonial property if it was acquired during the subsistence of the marriage. Remember, matrimonial property, there are two grounds, and the court will always look at two grounds. Is it a matrimonial home, and is there any contribution? So in your activities as a wife, when you're at home, or for example, if you're occupying that home up country, you're always maintaining it, you're cleaning it, you're doing housework. It's the same house where you do childcare. Over there, you effectively then have an interest in terms of your contribution to that home. So it's basically to look at it holistically like that. And yes, to your city home, your husband does have a claim or does have an interest in that property, because as we've seen, it's a matrimonial home. It's where both of you live, and you do have an interest to that upcountry home, depending on the utilization of that home and the sort of contribution that you have put in terms of childcare, in terms of housework, in terms of farm work, and also if you have improved it in any way, if you've replaced, reworked anything, you've improved and elevated the status of that house, then it's matrimonial property and you have an interest based on your contribution to that property.
Wow, thank you so much, Annette. I think you're really doing justice to these questions. And I think I'll just read like three more, then you can handle them together, because I really desire we end at 10, as one of us had suggested. And somebody asks, assets acquired by each spouse separately, e.g. of 4-year separation and later followed by divorce, is this termed as matrimonial property, which can be shared? So there's a separation here that has happened for about 4 years. The two spouses are separately acquiring property, and then finally they divorce. How do you administer such a property? And then somebody says, what is the current government doing considering the murders of spouses, that it seems to be increasing on a daily basis? And I think this is a key issue, whereby you find a lot of property now is ending with the UFA, like Mwangi was saying, because people are acquiring property and they will not disclose because they are afraid of I'm avoiding using one that was used in some platform, but somebody is scared that if I disclose that I have this property, then it gives a justification for somebody to be murdered because they want to inherit and all that. And then maybe a third one, I think this is loaded. Maybe you could answer those two and then we can pick another one.
Okay, I think later on I'll seek clarity on the second question, but I can answer the first question. So to understand it and to get it right, you were married, then you separated for 4 years, and within this period of 4 years, both of you were acquiring property separately, and eventually you divorced. So the question is, this property that's acquired during separation, what happens? Remember, matrimonial property, and the courts usually are not eager to make a decision when it comes to a situation where the parties have disagreed, but they have not yet divorced. The court will only want to address itself to a situation where the parties have actually divorced formally, and a decree has been given by the court that they have been divorced, and therefore distribute the property, and then determine what right people have to the property. But remember, matrimonial property is property that has been acquired during the subsistence of a marriage. Even when you have separated, you are still legally married, and until a decree absolute is given to determine that both of you have divorced, you are still married. So for all intents and purposes, that is matrimonial property, if it was acquired joint during the subsistence of that marriage. But remember, there's that qualification. If it's jointly acquired during the subsistence of that marriage, it can be argued that you had separated and that you had acquired that property individually in your own name. But remember, there's a presumption that when you acquire property, you're holding it in trust for the other spouse, even if you did it alone. But this presumption is what we call a rebuttable presumption. And under the Matrimonial Property Act, they actually indicate that it's a rebuttable presumption. As much as we're presuming that you're holding it in the interest or in trust for the other spouse, it can be rebutted. And one way the courts look at this, first of all, is that we had separated, we were not talking, and this property I acquired when I was alone, and we really didn't have any sort of interaction between ourselves. We were married, but socially, really, we weren't living together in that sense. But also remember, the court usually has another additional standard, which is contribution. You just cannot claim that this is spousal property or matrimonial property because we acquired it in the duration of the marriage. The court and the act itself usually requires the party to put to task what their contribution to this specific property was. So in this situation, you are separated. And if this other party comes and claims that this was matrimonial property, yes, it was obtained during the subsistence of the marriage. But can you prove your actual contribution to this marriage? So monetarily, of course, they cannot prove in any way that they paid for the property because they did. You were separated. Number two, even from the non-monetary aspects, you cannot contribute non-monetarily, which is taking care of children, doing all those things, without necessarily being together. Sometimes in a house where it can be seen that you're contributing in a non-monetarily way for the benefit of the other person. So in that situation where your property can be protected when it comes to the aspect of proving contribution, as long as you can prove that this other person did not contribute to the property, despite the fact that it's matrimonial property that was taken during the period of your marriage, but if you're able to demonstrate that they did not contribute in any way, then they do not have a claim. And case law is very specific. The courts usually want to see, did you contribute? either monetarily or non-monetarily. So the onus is on you then, as you're defending your property that you acquired during separation, to demonstrate that your spouse during this separation actually did not contribute. And if you effectively do it to the court satisfaction, then your property is safe. And then Irene, the second question was on the issue. You mentioned something to do with being murdered.
Yeah, I'm not sure this is really for you, but somebody was just concerned and asking what is the current the government currently doing, considering the murder of spouses, and it seems to be increasing on daily basis. Of course, they needed to maybe relate that with the issues of property and all that. This is the issue of the government. I'm not very sure that it is in your capacity to answer, but you can comment. But while at it, you can say you can answer this one that says a man married and had a son with the wife, of course, and then separated. Then the man later on married a wife at an old age and died after 5 years of the marriage, but without a child with the second wife. So the father, the father of this man had left an inheritance for this man who died, who has the right of such an inheritance, the son of the first wife or the wife without a child. Note that the grandfather wished his property to be inherited by his children or grandchildren. I hope you've gotten the question.
Yes, I have. So I will first cover the issue of spouses being murdered and what the government is doing about it. Remember, murder is a public interest criminal issue. So we're looking at it from two situations. It's a criminal issue, first of all, to murder someone. And there's a whole provision and there's a procedure under the Criminal Procedure Act and under the Penal Code to prosecute a person who is suspected or who is accused of having murdered someone. So in terms of the punitive, or rather the implications of murdering someone, there's a whole criminal procedure that is followed to determine whether a person indeed murdered someone and that they had the motivation and the intention to do it and that they did it, and then they're convicted and they go to jail. So there's that criminal aspect of punishing someone who's murdered someone. Then now when it comes to property in that situation where a person then has gone to jail and they were the surviving spouse, one spouse is murdered dead, then the other one has then gone to jail. What happens then is then a decision has to be made in terms of the use of that property for the benefit of the beneficiaries. And so it could be the beneficiaries of the estate of this deceased spouse going to court and saying that, hey, we were depending on this person, he or she is dead. The person who survived the spouse is in jail and is unable to administer the estate of this deceased person. Then they proceed with the process of getting letters of administration to be able to benefit from the estate of the deceased person. I hope that makes sense. Then, so there's the criminal aspect, and then there's the whole succession situation when it comes to the benefiting of the property of a person who has since died. Then, in the other question where a man was married and then he had a son, separated, he married again in old age and then died, who has an interest in the property? So it first of all depends. Did he have a will? Okay, fine. And if he had a will, what did it provide? Because ideally then, if you're saying that his wish was that his children inherit his property, if he had a will, it would have been set out over there. So I don't know what the specific situation is, but if he had a will, in that case, then the wishes of the person are set out under the will then be enforced by the people who have been appointed in the will as the executors of the will, to the extent that it doesn't exclude people who have a rightful claim to that property, for example, beneficiaries such as underage children. In the situation or in the occurrence that this deceased person did have a will and he remarried, both parties, his son and his wife, then have a claim to the property, because remember, under the Law of Succession Act, we have a wife, and the wife usually will have immediate, and they will absorb the interest in terms of the matrimonial home and the personal effects of the deceased person. And then this son, depending on their age, if they're underage, this is a dependent under the Act, and they need to be taken care of. If not, they are a family member, and therefore, by virtue of this relationship, they are a beneficiary with a rightful claim to the interest in the property. So it will depend on both situations, where there is a will and where there isn't a will, and I hope I've been able to elaborate on it.
Wow, thank you so much. And it is 2 minutes to 10, and I really desire that we end it at that. Members, if you looked at the topical areas that we really intended to cover today, you realize, of course, there was the legal aspects of property acquisition, then there was joint ownership versus co-ownership, and then the number 3, which I think now is where we are dwelling a lot on, is on the aspect of separation and divorce in regards to matrimonial property. There's the aspect of succession and inheritance, and then there is dispute resolution. At the end of the day, the dispute, until we get to the point of dispute resolution, I think we will not have been able to handle this a lot. Annette, for your information, so many questions have come through. People have pending cases, and they're wondering why they have been, the cases are living like forever in courts, and they are not being determined. But as now time has it, I think we'll just answer one question, and we will talk so that we see how to finish this, because we need to talk about these divorce issues and what happens, and then at the end of it, we need to know how do we resolve these disputes. I am keeping these questions so that we can respond to them in the next session. Members, just relax and trust us once more time. We are going to land and land safely. And as we conclude, I think this question basically must have been touched on, as Annette presented, by saying if a spouse consented to buying a property but did not contribute to repayment of the mortgage, and later they divorced, can the spouse come later and claim part ownership of that property? I think she mentioned about how the interests are vested on every member, but let's leave it at that. It's already 10 p.m. Annette, somebody is already asking for your number because they would need some personalized attention in this matter. And I can tell you, members, if you need any professional attention in such matters, I can confidently say Annette is the go-to person without shaking. I feel like there's someone who is really trying to say something. I don't know who that is. Like they really want to say something. Is it Delphine? There was also Florence. Your microphones are on. Unless it's really, really, really burning, I want to close this session at this point, and promise that, God willing, coming Monday we meet on this place, same platform, same time. We will see how to handle those who have personal inquiries, and those that would need guidance of our presenters for the day. And I'm definitely forced to bring this to a close at this particular point, but just to give Annette just a minute or two to do your closing remarks, and then we will do this again next Monday. I pray that we'll all be available. Annette.
All right, thanks, Irene. For those who requested for my contact, I think you can get it through Irene. Irene, sure. You have my number, my email. Feel free, you can share it. I don't mind at all. And then for the other questions, I don't know, Irene, I'm sure you must have access to the chat once we close.
Yes.
Yeah, so maybe I can be able to answer the questions, the remaining questions, if and maybe they can be shared. I don't know how they can be shared, but I'd really like to maybe see the questions that haven't been answered, and I can try and answer them, and they can be shared to the members. And yeah, so my closing comments, I'm grateful. Thank you so much, guys, for having me. Topics like this are very close to my heart, especially property rights, women property rights, financial inclusion of women. Things are very, very close to my heart. And I'm always so grateful to build capacity and to discuss these issues with other people. I'm grateful to Hallmark for giving GVA, our law firm, this platform to be able to learn, educate, and engage. I look forward to interacting with you guys further. You can, so my email address is aakam@gvalawfirm.com. I will share these slides with Irene to share with you guys. My email is down there. You guys can always email me if you have any questions. I also dabbled in employment, labor, dispute resolution, pensions, etc. So I'm an all-round corporate and commercial lawyer. And all I want to say is thank you, guys. I hope this has been informative, and hopefully we can do this again sometime soon.
Definitely, we will have you, Annette. You're very resourceful, and definitely there's a lineup of matters of public interest that we need to cover on this platform of Hallmark. We'll always be glad to give you that opportunity to speak your heart. I love the passion. Honestly, I think this comes with passion. And so members, as we've done this before, for those who have joined us for the very first time, we said we have dealt with the different issues before, and we are just delving a bit deeper as we desire to form a whole well-rounded person. And it can only get better. It can only get better. We have this session. I'll definitely share the content to as many as possible with the permission of the presenters, so that at the end of the day, we definitely achieve the objective of this platform. Next time when we are meeting, please spread the word. Let's all come. I was saying, if you can come with your spouse, if you can come with your brothers, if you can come with your parents, it would be easier for us to address this matter so that the disputes are handled accordingly. And with those many words, I think in respect of time, I want to just declare that this session is closed. We will share the questions that have not been answered, and Annette will be able to respond to them, and I'll give this feedback to as many people as I've asked. Be sure to register with the link that was shared so that you're included on the WhatsApp group for you to be able to get more information. Other than that, I'll be able to, I just want to declare the blessings of God upon you as you go to rest. May you have a restful night. May you be refreshed, and may God really bless you, and may you have a very fruitful April. We keep seeing you transform lives. God bless you so much. You feel free to live at your own pleasure. Thank you.
Thank you, everyone. Bye. Bye.
Asante sana.
Thank you. Bye.
Asante.
Be blessed as well. Good night.
Amen. Thank you.
Bye.